Okay. Well, thanks again for joining us today for this roundtable discussion about antitrust enforcement in the education sector. We're so glad you could be with us. Before we get started, here are some items to note for the program. If you have any questions for the speakers, please enter them into the Q&A box. We're going to do our best to answer them during the last 10 minutes or so of the webinar. But if we run out of time and your question's not anonymous, we are happy to follow up with you afterwards. So with that, let's get started into the substance of the program. In our webinar today, we are going to be providing an overview of issues and sticking points that your institution may encounter during this period of heightened antitrust scrutiny, and we're going to provide some takeaways for practitioners. I'm Stephanie Gold. I'm a partner at Hogan Lovells based in Washington, D.C., and I lead our education sector team. And I'm joined today by Holden Steinhauer and Sarah Keller.
Thanks, Stephanie. Hi, everyone. I'm Holden Steinhauer, and I'm a senior associate in the antitrust group in the DC office of Hogan Lovells.
Hi, everyone. I'm Sarah Keller. I'm an associate in the antitrust group in the Northern Virginia office of Hogan Lovells. I also have a background in higher education and hold a master's in higher education administration.
Terrific. Thanks, Sarah and Holden. So as I mentioned when we started, this is an era of aggressive antitrust scrutiny. The DOJ, the FTC, state attorneys general, and private plaintiffs have all been extremely active in bringing investigations and lawsuits in the antitrust space. So what does this mean for the education sector, and how and in what ways are these changes most likely going to impact you? The education sector is definitely on the minds of the regulators. Recently, Doha Mekki, the Principal Deputy Assistant Attorney General of the DOJ Antitrust Division, said, quote, "Antitrust enforcement plays a really important role in making sure that education, however you define it, is both available to all Americans and affordable for all Americans," end quote. That is why we're here to discuss today what's going on in education sector in terms of antitrust developments. And we're going to discuss certain elements of the day-to-day work that leaders in the education sector and the challenges you're facing, and how this current antitrust climate impacts your current or planned operations. But before we dive in, Holden, maybe you could give us a little bit of grounding and context for this discussion.
Sure, Stephanie. So at a basic top line level, U.S. antitrust law is concerned with preserving and promoting competition. And antitrust law focuses on two concerns that directly harm competition. Agreements, particularly among competitors, that reduce competition, so price fixing or market allocation, because such agreements require companies to coordinate behavior rather than compete. And the second is exclusionary conduct of firms with significant market power, because such exclusionary conduct makes it hard for other firms to compete, again, harming competition. And it's from these two concepts that you really have sort of the wellspring of all of antitrust law. But from those basic and very fluid ideas, enforcement agencies can find varied and novel theories of liability. And so for leaders of for-profit and nonprofit organizations, it's not always clear how ordinary business conduct may run afoul of the antitrust laws. And there has perhaps never been a greater uncertainty in this space.
So a lot of what you just shared focuses on competitors and is a word we all know colloquially. But Sarah, how should higher education institutions think about the concept of a competitor?
We all certainly have some intuitive notions of what might constitute competitor firms. But for antitrust law, identifying a competitor really should be a broad exercise. Coke competes with Pepsi and Honda competes with Ford. But schools compete with other schools for more than just students. They compete with schools for other businesses for employees, which includes everyone from professors to administrators to lawyers to maintenance workers and everyone in between. If the institution owns a hospital or medical facility, they may compete with other hospitals and doctors' offices. Their school store may compete with local businesses to sell sweatshirts, and they may compete with other schools for both student athletes and television revenue. Institutions are also unique in that an institution's competitors may be different for each sector or segment of the institution. For example, Stanford may compete for the same football players with the University of California, Berkeley, but might compete for the same tenured faculty with the University of Chicago. And to add to the complexity here, the fact that schools are competitors in the eyes of antitrust laws and their enforcers does not mean that institutions cannot have any sort of collaboration. Antitrust law is not that cut and dried. For example, an Ohio State professor could still write an article with a Michigan professor.
Thank you, although maybe not about football. Before getting into some of the specifics, we should also talk about penalties. What are the penalties for violations of the antitrust laws that institutions and administrators should be aware of?
Antitrust law carries significant penalties. These are not just parking tickets. They are designed to deter conduct, and violations can result in liabilities both for the school itself and for the participants. And there are both civil and criminal penalties for violating the antitrust laws. The current DOJ has shown a willingness to prosecute individuals who participate in violations rather than prosecuting organizations. The theory seems to be that the effect of individual prosecutions is likely to keep the corporation in line. And just a quick aside related to this on antitrust enforcement against public universities. In short, the state action doctrine in antitrust law generally protects a state from federal antitrust liability, but there are nuances and exceptions to that general principle. As relevant to our discussion today, the federal antitrust enforcers have taken the position that state action immunity applies quite narrowly to public educational institutions. And if an institution is acting as a participant in some market and not as a regulator acting at the direction of the state, enforcers will seek to impose the same sorts of penalties as they would on private actors. When enforcing antitrust laws, a court may issue an injunction, which requires ceasing the action at issue, or may prescribe certain other behavioral changes. Injunctions can be issued by a court against an institution, but also, for example, a private trade association of which an institution is a member. So a court could issue an injunction against the NCAA, which would require all schools that are members of the NCAA to comply with that injunction. Injunctions could cause operational issues depending on the scope and area of an institution impacted, and courts can issue injunctions that might really upend ingrained organizational practices. Injunctions may also cause issues among competitors when some competitors are subject to injunctions, but others are not. For example, one institution applying for a research grant might be subject to an injunction, but its competitor institutions may not be, and this could have the effect of putting an institution subject to an injunction at a competitive disadvantage.
Thanks, Sarah. So I think we're now going to talk some more specifics and address some specific topics and scenarios that show how these ideas and how the changing enforcement landscape may be most relevant for the education sector. So first, Holden, many higher education leaders participate actively in trade and professional associations. Can you explain how antitrust law regulates that sort of activity?
Yes, as you say, Stephanie, often higher education administrators, practitioners participate in these sorts of professional associations or consortiums where they can discuss best practices, discuss how to improve their organizations, discuss how to support students, support donors, support other stakeholders to the school. And so we're thinking about groups like the Consortium of Financing Higher Education, the National Association of College and University Attorneys, the American Association of Collegiate Registrars and Admissions Officers. Trade associations are an important aspect of many industries, most industries maybe, including and especially higher education. But it's important to make sure that your institution's participation in those sorts of organizations is appropriate and doesn't violate the antitrust laws. This is this is a great quote from Adam Smith's The Wealth of Nations. Quote, "People of the same trade seldom meet together, even for merriment and diversion, but the conversation ends in a conspiracy against the public or in some contrivance to raise prices." That's a sentiment I would imagine that is not likely shared, by many education leaders, and it's probably not shared by a variety of other industries for which trade associations are a regular and ordinary part of how organizations learn to improve and learn to better serve their stakeholders. And obviously, it is not the case that a gathering of competitors at a trade association meeting would generally or always violate the antitrust laws. This is a quote from a Ninth Circuit case. "Trade associations often serve legitimate functions, such as providing information to industry members, conducting research to further the goals of the industry, and promoting demand for products and services." But even simply participating in a trade association does present, some antitrust risk. And under antitrust precedent, that simple participation in an industry organization can be what is called a plus factor, some circumstantial evidence supporting an inference of having entered into a conspiracy, because trade associations, quote, "provide opportunities to exchange information or make agreements." That's a quote from a recent Northern District of California case. So as an example, I'm sure most folks on the call today are familiar with the 568 President's Group litigation. The plaintiffs in that case alleged a conspiracy by 17 universities to reduce financial aid awards. So in effect, fixed tuition at an artificially inflated rate. And at the center of the case was the 568 President's Group. The group was formed pursuant to a statutory exemption in the antitrust laws to allow schools to work together to increase access to higher education. That litigation is still proceeding. We don't have a final ruling on the merits of the plaintiff's claims, but at an early stage of the case, ruling on the defendant's motion to dismiss, the court in that case found that the plaintiffs had sufficiently pleaded in their complaint allegations that the defendant schools had suppressed competition by working together, and that absent this collaboration, the institutions would have competed more earnestly with one another to provide competitive financial aid packages. So what are some of the takeaways here? What can we do looking ahead? I think there are a number of practical steps that institutions can consider for their participation in professional organizations. So participants should get approval to attend any trade association meeting, particularly if it is a new gathering, a new meeting that maybe the institution hasn't participated in before. Participants should send agendas for trade association meetings to in-house counsel for review. You should follow that agenda, without deviation when meeting with competitors. Trade association meetings should all include some set of antitrust compliance procedures or rules, some ground rules about what sort of conduct is acceptable, consistent with the antitrust laws, and to which all participations of a meeting would agree. Participants should be sure that there is some form of an antitrust statement read at the beginning of the meeting, setting out the ground rules by which everyone agrees to abide. If feasible, make arrangements to have an attorney present who is there to monitor and make sure conduct is lawful. If feasible, participants should keep minutes of the discussion, keep a record of the sorts of topics discussed and the information exchanged during these sort of meetings. Try to avoid sort of hallway or informal discussions with your competitors about sensitive topics. If you are at a trade association meeting and you're in a conversation, you begin to feel uncomfortable. You begin to feel like there is some sort of an agreement, forming between competitors who are, chatting amongst themselves. Remove yourself from the discussion and do it noisily. Don't just walk away. Make sure, if you have employees of your institution attending these meetings, if they find themselves in these sorts of uncomfortable positions with competitors, state that they are departing so that the remainder of the group knows for certain that they've left the discussion. It's not a situation, where you should worry about being rude. There's a lot more that could be said here, I think, about these sorts of organizations and sort of proper conduct during these sorts of meetings. I'll just make just kind of one more point in particular. Participants, when they're in these sort of meetings with competitors, should be careful not to form any sort of an agreement. And an agreement could be expressed, but it could also be implied through conduct. So, going back to one of our earlier slides, that's one of the principal foundational elements of antitrust law and what enforcers are looking for. Did competitors form an agreement with one another?
Yeah, on that point, Holden, one of the takeaways from the discussion so far, I think, is the importance of the concept of agreement in antitrust law, which may be a more nuanced concept than one might think at first. So maybe you could talk a bit more about that.
Yeah, look, at a basic level, an agreement, just means the meeting of the minds on a course of conduct. But when we're thinking about how it applies, the concept applies in antitrust law, an agreement does not need to be reached through any sort of formal written contract to potentially be enforceable, to potentially generate risk of liability. Agreements can be implicit. They can be inferred from conduct. So as a result, mere discussions followed by some conduct that looks like it's in conformity with the discussion, it could give rise to an agreement, which could create antitrust risk. So here's like a very simple hypothetical. You have a small group discussion of 6 administrators from like institutions. They're discussing tuition issues following a trade association, session on the subject. So let's say during this conversation, someone says, I don't know about the rest of you, but our institution, we're going to charge $60,000 for, tuition next year. A second administrator chimes in, what a coincidence that, we're planning to do the exact same thing next year, $60,000. Everyone disperses from the meeting. Following year, all 6 institutions have a $60,000 tuition rate. In the eyes of an antitrust enforcer, that looks a lot like an agreement as to price between all 6 administrators, even the 4 that didn't actively participate in the conversation.
So higher education is an industry of best practices, and practitioners across the industry work to build best practices within their organizations, and often reference the success of other institutions or systems of higher education when they're developing best practices or analyzing their own practices. So how do you suggest practitioners balance sharing and building best practices without crossing that line into what might be seen as an agreement under antitrust law or by an antitrust enforcer?
So under current antitrust precedent, an agreement simply to exchange information is not per se illegal. And what that means is that sort of an agreement is not necessarily and flatly illegal. Information exchanges between competitors are generally evaluated under what's called the rule of reason, which is a standard in antitrust law that requires a plaintiff to show basically 2 things. 1, an agreement to exchange information, but then also 2, a harm to competition from the purported information exchange, which outweighs any pro-competitive benefits. And so, although courts have recognized pro-competitive reasons and pro-competitive benefits for competitors to share information with each other, if the information exchanged is competitively sensitive, sharing of such information could lead to less vigorous competition and thus, create an antitrust problem. And just sort of a quick word on the terminology here. The antitrust laws are most concerned with an exchange of competitively sensitive, non-public information. And so by, quote, competitively sensitive, we mean information that could signal, amongst competitors, how they're likely to respond to some particular course of conduct. So, for higher education, what does that mean? Well, I think the definition could vary, but some examples of sort of what we're talking about here of competitively sensitive non-public information would include, information regarding the inputs and methodologies to a financial aid process, budgeting, intellectual property, bidding processes, student recruitment, student admissions. All of that could be competitively sensitive non-public information. So in 2023, the Department of Justice and the Federal Trade Commission withdrew information sharing policy statements. Now, these were specific to the healthcare sector, but they had sort of been widely viewed as providing sort of safe harbors for competitor information exchanges, that would apply and were sort of seen as significant, in a number of different industries. And that is sort of indicative of the kind of current climate, we're living in with these issues, that, this safe harbor, these clear policies upon which we were previously relying, now they're gone. And in recent public statements, DOJ has really emphasized that even exchanges of data and information aggregated across many competitors could be considered anti-competitive. And further, an exchange of information between competitors could also implicate a more serious violation. That sort of conduct could be some evidence of a per se illegal agreement, a flatly illegal agreement, a necessarily illegal agreement, like a price fixing agreement. So just like how we were discussing earlier about how participation in an industry association could be some circumstantial evidence of a per se unlawful agreement, an information exchange between, supposed co-conspirators, competitors, could also be seen as circumstantial evidence of this sort of very serious price fixing agreement. So look, the purpose of today's discussion, we're certainly not trying to scare institutions away from permissible collaboration with peers. And, like we were discussing earlier, it's a big part of the industry. Higher education leaders are this is what they're familiar with. But we want to caution institutions about what types of information that they share, how they do it, and to be cautious of the purpose and the effect of any kind of information sharing. So a couple of sort of rules of thumb here. Information sharing should be limited to publicly available or not competitively sensitive information. Information sharing should be limited to information that is reasonably necessary to accomplish some sort of lawful organizational objective, some sort of helpful pro-competitive purpose. And ideally, information sharing should be limited to aggregated data, data that doesn't allow viewers or users to, ascertain, specific institutions, from the information. You should avoid sharing competitively sensitive information, such as price, cost, strategic planning information. Competitor institutions should avoid sharing current or future strategic plans, business plans, and avoid sharing institution-specific data.
Thank you, Holden. So that really covered a lot of ground, and we've discussed trade and professional associations, and we've talked about information sharing. I think we're going to shift a little now to cover some other topics and scenarios that should be top of mind for higher ed institutions, and where we have seen a lot of antitrust focus and enforcement activity of late. So I think, Sarah, you're going to cover some of these areas where higher ed's been kind of implicated.
Yes, an additional topic that higher education institutions should be aware of is faculty and employee recruitment, hiring, and retention. This is an important part of an institution's growth and success. Organizational strategies and decision-making around recruitment, hiring, and retention are complicated, and there are so many factors that leaders need to weigh, including maintaining budgets, maintaining organizational culture, and complying with regulations. But recruitment, hiring, and retention also implicates certain antitrust risk as well. Among the types of agreements between competitors that enforcers have been targeting, especially recently, are no-poach agreements, which are agreements between competitors not to attempt to hire each other's employees. Just like antitrust law is concerned with the competitive dynamics in markets for goods and services, it is also concerned with competition in labor markets. agreements between direct competitors not to compete for labor suppresses competition in those labor markets. As an example, in June of 2015, a professor at Duke Medical School filed a class action lawsuit alleging that Duke and UNC had agreed with each other not to hire each other's faculty. 4 years into the litigation, in March of 2019, the DOJ filed a statement of interest in the case, making clear the government's view that no-poach agreements between competing employers are per se unlawful unless they are reasonably necessary for a separate legitimate collaboration between those competitors. For example, a collaborative project between two universities where a no-poach clause is supported by a pro-competitive justification, such as protecting trade secrets and confidential information, and the clause is narrowly tailored to match its purpose. Then, after the parties announced a settlement in the case, the DOJ intervened to join that settlement agreement. The settlement provides a $54.5 million fund for a class of medical faculty, but it also provides the DOJ with the authority to inspect documents and interview employees to ensure that the universities refrain from using no-poach agreements for the next 5 years. The DOJ told the court that allowing the government, quote, to intervene in this matter will further the United States' significant interest in preventing anti-competitive no-poach agreements in the future. Likewise, the DOJ has commented in its 2016 antitrust guidance for human resources professionals that, quote, if you stopped recruiting and bidding for faculty from another university due to a gentleman's agreement, you have become a member of that no poaching agreement and could be subject to criminal liability. You should take no further action to comply with that agreement and notify your university's legal counsel of the university's participation in this illegal agreement. Another type of agreement relative to this discussion are non-compete clauses, whereas no-poach agreements are agreements between competitors or, in antitrust verbiage, horizontal agreements. Non-compete clauses are agreements between an employer and an employee that the employee will not, after leaving employment, compete with that employer, usually for some designated amount of time and in some measure of geographic distance. Traditionally, courts have viewed non-competes as having some pro-competitive benefit and have found them lawful so long as they are reasonable in time, scope, and geography. However, in April of 2024, the FTC approved a rule that would institute a nationwide ban on non-compete clauses with some minor exceptions that are likely not applicable in the university setting, which was recently blocked on a nationwide basis. If that rule had taken effect, it would have banned the use of non-compete clauses nationwide, classifying such clauses as an unfair method of competition under Section 5 of the Federal Trade Commission Act, and employers would have been required by just last week on September 4th to send out notices informing those subject to such agreements that they were no longer enforceable. Given the FTC's unprecedented legal position, most antitrust observers were expecting the rule to come under challenge and be struck down, and that's exactly what happened. On August 20th of just this year, Judge Ada Brown of the U.S. District Court of the Northern District of Texas held that the rule is unenforceable nationwide, rejecting the FTC's argument for a more limited remedy. This is a positive development for employers who have been in limbo for months over the rule. Although the court's decision may be appealed by the FTC to the Fifth Circuit, it is unlikely that the Fifth Circuit will overturn the district court's decision, and such an appellate process will likely take months or years to conclude, and the case could ultimately end up before the Supreme Court.
I'm sure that many of us will be watching closely how things evolve on this topic. But for now, what are some of the takeaways that practitioners and institutions should be aware of?
As for no-poach agreements, employers should exercise great caution before entering into an agreement with an employer in which they agree not to hire each other's employees. Unless such agreements are necessary for legitimate business competition, the FTC will view such agreements as illegal. As for non-competes, due to Judge Brown's decision, the FTC's non-compete rule did not take effect on September 4th and may never take effect, meaning employers are not prohibited by the rule from entering into new non-competes and need not have taken steps by September 4th to comply with the requirements of sending out notices and validating existing non-competes. That said, institutions should follow how legal challenges continue to evolve over the FTC non-compete rule, and all employers should remember that non-compete law continues to primarily be regulated by the states. States take a variety of different positions regarding if and when non-competes can be enforceable, and employers that require their employees to sign invalid non-competes can face liability under certain state laws.
Thank you, Sarah. So that was a really helpful overview of important antitrust concepts in the recruitment, hiring, and retention of faculty and employees. I know another area of focus has been athletics, and how that has been playing out in terms of antitrust developments. So can you just remind us how that all started?
Yes, college athletics has certainly been a hot button issue in the news, on campus, and in antitrust laws in recent years. You may all remember the Alston case from 2021, which ushered in a big paradigm shift for student athlete compensation. As most of this group likely knows, the Supreme Court decision in NCAA v. Alston found that certain NCAA rules impermissibly restricted student athletes from receiving certain educational related benefits.
Yeah, and so I think a lot of folks know that following Alston, there's been a lot of cases related to college athletics. What are some that you want to kind of highlight in particular?
Yes, you're correct. There has been significant litigation recently that may upend university operations and college athletics. One of those cases is the House case. The plaintiffs in House alleged that although Alston opened the door for athletes to receive payment for use of their name, image, and likeness in endorsements and other marketing campaigns, athletes were still barred from receiving payment from universities for their respective name, image, and likeness when used by the university. The plaintiffs alleged that the NCAA and its members violated antitrust laws by fixing the amount that student athletes may be paid for a licensing, use, and sale of their name, image, and likeness at zero. The House plaintiffs challenged this restraint, and the proposed settlement seeks to resolve athlete compensation and scholarship limits generally, including but not limited to those name, image, and likeness issues. The parties reached a settlement earlier this year, which was filed on July 26th of 2024 and is currently under review. In fact, there was just a hearing related to the settlement just last Thursday. The House settlement will allow institutions to distribute up to 22% of the institution's average broadcast revenue to their athletes. This is currently expected to be around $22 million per institution. Colleges and universities have discretion to disperse those funds at their institution how they see fit. Institutions and athletic departments will need to decide how to allocate those funds and will need to consider important implications for the distribution of those funds, such as Title IX. At least some officials at the Department of Education have stated that payments must be made in accordance with university obligations under Title IX. If the settlement is approved, the first year of the settlement's terms will be 2025 to 2026, which is next academic year, and leaves schools with little time to iron out how they will implement these payments, especially when considering that these disbursements will impact recruiting decisions, and that recruiting process is underway for the 2025 academic year as we speak. A second case of impact is the Johnson case, which, although it is not an antitrust case, will still have interesting implications for college campuses. In that case, the court is currently in the process of deciding whether college athletes are employees. There are a number of ways that this might have a big impact on institutions, including minimum wage payments, the potential for workers' compensation obligations, and unionization, at least for private institutions and certain state institutions. If college athletes who have incredibly high injury rates are deemed employees, the question becomes whether institutions may be responsible for an incredibly large number of workers' compensation benefit payments. And in states where unionization of state employees is possible, institutions might need to bargain with their own students. So overall, what we've seen in the past few years is that antitrust issues can extend beyond the pay for play that is discussed when news sources and the public discuss large scale college athletics, which is often focused on FBS and March Madness basketball. Antitrust can touch all levels of college sports. So in terms of takeaways for college athletics and looking ahead, suffice it to say, college athletics has changed significantly since the Alston decision and will continue to change significantly again in the wake of final decisions in House and other litigation that is ongoing against the NCAA.
Thank you very much, Sarah and Holden, for the great insight and discussion today. I know we want to save some time for questions, but Holden, what are some overall takeaways and suggestions that we have based on, all these topics we have discussed today, which may really be causing heads to spin?
Yeah, it's there's a lot to digest here, but we'll sort of go over, I think, a couple of different points that I think are sort of broader takeaways and things that folks can consider for their own institutions looking ahead. Look, it's a fast changing enforcement landscape in antitrust. And obviously the purpose of today's discussion is focused on higher education, but really across so many industries, it's like a different world. And leaders at higher education institutions should not just rely on their old playbooks, on the old compliance guidelines. It's important to continue to follow where and how things might be shifting. And what are higher education leaders accustomed to doing when faced with new challenges, when faced with a changing regulatory landscape? We often consult our peers, right? We look to trusted and respected peers to discuss, what are regulators doing, to discuss what best practices should be. And that's the ironic tension with what we're discussing here. More than ever, institutions need to be very careful about all sorts of collaborations with competitors. Be careful when entering into any form of an agreement with an institution with whom you may compete. And again, remember, when we talk about competing, we mean whether it's competing for students, you could be competing for faculty and staff, you could be competing for resources. And also remember that an agreement, certainly for antitrust purposes at least, it need not be a formal written document. It could be something much more informal. It could be something implied from conduct. Institutions must be careful about the use of listservs, ephemeral messaging applications, these sorts of communication channels that employees often use for more informal discussions. Because an offhand comment made via a shared listserv to a peer at a competing institution, it could take on a much more troubling and significant connotation if you're in the context of an antitrust investigation. Update your antitrust compliance policies and do it not only for your institutions generally, but also for specific activities, like for participation in professional associations, for participating in any kind of an information sharing or sort of best practices aggregation service. If you have not done so already, consider designating an antitrust compliance officer for your institution. Invest in antitrust training programs for your institution. I mean, it's a great way to help mitigate the risk of all sorts of different conduct, like what we've been discussing today. Remember, if you think there might be an issue, employees need to call the legal department, before acting. With the risk of serious enforcement penalties, with this sort of heightened enforcement landscape, it's better to seek authorization, seek counsel before acting. And finally, when in doubt, seek the counsel of experienced antitrust and education counsel. Do it early and often. The team here at Hogan Lovells, we're following and working in these issues, every day.
Thank you so much, Holden. So I am going to stop sharing the screen so that we can address any questions that we have received from the audience. So I think the first question presented. I'm going to take these in sort of a different order. So, are non-compete agreements restricting medical professionals at academic affiliated hospitals at risk of violating antitrust rules?
That's a great question. And the FTC non-compete rule that I mentioned earlier applies to any sort of company, corporation, employer. So for right now, due to Judge Brown's decision, the FTC non-compete rule did not take effect on September 4th, but institutions should follow how legal challenges to that FTC rule continue to evolve over time. So as of right now, their employers are not prohibited by rule from entering into new non-competes, including new non-competes with academically affiliated hospitals and medical professionals, but just stay abreast of how the challenges to the FTC's non-compete rule evolves over time.
Thank you, Sarah. So how could membership in the National Association of College and University Attorneys possibly cause an antitrust claim?
It's a great question. I mean, I think what we would say.
I'll just say there's probably a lot of NACUA people on this call. So.
Yeah. No, it's a great question. Look, I think what we would say is that it shouldn't. But just to sort of take kind of a step back here. I mean, I think the stereotypical sort of paradigm of an antitrust violation is, the smoke-filled back room of, robber barons, shaking hands. And, but practically speaking, antitrust litigation today is not usually like that. Courts are often looking for circumstantial evidence. There isn't often direct evidence like that of an agreement that violates the antitrust law. And so that's where this discussion about trade associations, I think comes in, because if courts are looking for sort of circumstantial evidence, when you have sort of regular and routine interactions between competitors, could that support, some theory that a plaintiff or the government puts out there. And then I think you have all the other issues that we discussed, which is that if you're in a professional association meeting, there are the potential opportunities for those sort of problematic collaborations. So look, all that's to say is we certainly don't mean to imply that simply participating in these organizations is or should be an antitrust offense. They're so important to this industry. They're important to a lot of industries, but it's about understanding the ways in which you participate in them. It's about understanding that doing so does create, I would say, kind of like the opportunity for risk is maybe a better way to think about it, and just making sure that your institution is really careful about what those sort of like compliance guidelines are, when you are collaborating with competitors, in an organization like that.
So there's a follow-up question posted that as to, are there examples of what attendees at a meeting can discuss when together at a professional association meeting? So not just kind of, the negatives of this, but sort of what are, and maybe this goes in part to the not like sort of non-public information kind of information sharing.
Yeah, I see there's another question about, is sharing any non-public information within associations problematic? Yeah, so let's talk about that a little bit. So first off, just as sort of a kind of a more basic principle, what is public, what is non-public? I mean, that's not necessarily an obvious question to answer. So for instance, if an institution publishes something on their public-facing website, that certainly seems like it's public. But what if there's some information about tuition, about programming, about budget that isn't published on the website, but if you were to call an administration office and speak to someone, they would tell you, does that make it public? So I think even these concepts about what's public and non-public are a little bit nuanced, and it would depend a little bit. And I think a private plaintiff or a government enforcer could take a different position than what an institution might say. But I think a couple of ground rules here. So we talked about how the sharing of competitively sensitive information is potentially risky. And I think the way I described it was, information that could signal how a competitor is likely to respond to a particular course of action. Because under antitrust law, there is greater risk in exchanging information if that information might influence the competitive decisions of another firm, allowing competitors to predict each other's plans. And so, to the point of the question, look, sharing sharing information that would be known to any sort of consumer, to the market, that's your safest bet, right? I mean, that's public information that's less likely to be problematic. So, if you think about for higher education, sharing information about current tuition would likely not be considered competitively sensitive because most schools ordinarily publish publicly their current tuition rates for current students and prospective applicants to see. But a school's internal calculations and planning for future tuition increases, that could be competitively sensitive information. So if you're in a trade association meeting, you're working and collaborating with competitors, the safest, the least risky thing to do is to talk about information that's public. Talk about things that are not non-public. Is sharing any non-public information within associations problematic? Look, I think it depends, and it's something that. Look, I see the question was posted anonymously. We'd be happy to, follow up with who's ever, interested to talk about this more. I think it depends on the circumstances. I think if there's a rule of thumb to keep in mind, it's this principle of, would this enable my competitor to sort of better predict what I might do? And remember that these institutions, although they're peers and trusted colleagues, are also competitors. So it's a nuanced area. There are sort of more clear, safe zones, but once you get into that area of non-public information, it is a lot of gray, and there is a lot of risk because of this sort of changing enforcement landscape. But it's the kind of thing that we'd love to talk more about. Feel free to reach out, and we can talk about it in more detail.
Yeah, so I don't think it's not as if then sort of a typical professional association meeting is like filled with, traps and, problems. Like, it's just that it needs to be one just needs to be mindful and can be there's no problem with having discussions with competitors at professional association meetings. It's being mindful of like that, where you're sort of potentially blending in, verging into non-public information and creating something that might seem like an agreement from an enforcer's perspective. Like we're not there. It's not as if it's like, per se problematic to be having association meetings. It's that you just need to be sort of mindful that you're working within the zone of non-public information.
I think that's exactly right. And I go back to the, some of the takeaways and the practical steps we talked about here. That's why it's important to kind of invest in compliance policies. Have an antitrust compliance officer for your institution for these meetings. Have sort of clear ground rules, about what can be discussed, what should be discussed, what proper conduct is, because these sort of collaborations are so important for the industry, and they improve access to education. It's important for the industry, and it's important to do it right. And I think that's definitely kind of what we're trying to emphasize for sure.
Thank you. Would a change in the presidential administration result in more, less, or the same scrutiny of antitrust issues in the higher ed space, do you think? And, here in DC, we like to think we can try to predict these things, but right. I'm not sure that these things are predictable in this day and age. But you can take a stab at it.
Yeah, and I'm curious Sarah's thoughts on this. Look, I would say I wouldn't assume that. That's probably my personal view. I wouldn't assume that if we had a change in administration, things would be different. I think it depends on the industry you're talking about. I think it depends a little bit on the sorts of conduct, but I don't think it was the case that in the Trump administration, the antitrust division at DOJ was, totally lax. I think we saw a lot of enforcement, regardless. Would we expect some changes? Probably. Would we expect investigations or litigation that are midstream to stop? That would surprise me a bit. I don't think that's what we would see. So, I don't think a takeaway should be, if there's a change in administration, we're suddenly going to be faced with a new world. I think there's a lot of reasons to think that these trends would continue, and that a lot of these issues we have seen, some agreement, across the political parties about. But Sarah, I don't know if you have a different take on it.
No, I completely agree with everything that Holden said. I think there's no indication that there would be huge upheavals in change. To be sure, as Holden said, there could be, slight changes based on industry or the type of agreement or anything like that. But wholesale, I don't anticipate there being large changes no matter who is elected in November.
Yeah, I mean, I think the student athletics area is, particularly fascinating right now in terms of how that's intersecting with antitrust laws. And just a question I have, I know the House settlement is, maybe sort of given the court hearing last week, sort of on a sort of uncertain ground, but you had said that it could mean that schools would have to pay up to $22 million to their student athletes, which is a whole lot of money. I mean, what is envisioned in terms of the source of those funds?
That's a great question. And that's why some of these large settlements and some of these cases against the NCAA right now could really upend the way that college athletics works, but also ways that the universities function. The settlement itself states that that $22 million will come from the institution's broadcast revenue. But as any practitioner on this call will know, that revenue has previously been allocated, likely at the university's athletic department level, for other things, such as facilities or supporting travel of a different athletic team or any number of operational costs. So schools will need to get creative with how they comply with the possible House settlement and still meet their other obligations, both to their student athletes, to their institution, to their other students, and how they comply with other federal laws such as Title IX, which we mentioned may be impacted by this House settlement as well.
Yeah, thank you. So it looks like we've answered all of the questions in the Q&A. If you still want to put a question in there, please do. But maybe Holden and Sarah, you could, share any closing remarks you may have for the participants.
Yeah, I think that among the takeaways that we gave, probably the most important, just to sort of put a pin in the conversation today, is don't rely on the old playbooks, right? I mean, I think that antitrust enforcement in higher education is not new. I mean, that for decades we've seen high profile enforcement, but just things are changing. And I think that there's a risk in sort of assuming that the way we've done things or our understanding of the law, of policy, keeps our institutions secure. Think about updating those policies, thinking about taking a fresh look at it, taking a fresh consideration of where enforcement is going. Because I think, we don't want to leave folks on the call today with the sense that this sort of activity, this kind of conduct that we've been discussing, that it's not an important part of the industry, an important part of your institution. It's about doing it right. It's about consulting counsel and getting it right to go ahead. So look to update those policies, look to update your compliance, keep up to date on what's going on, and reach out if you need advice.
And I'll just close with, it's complicated. We know that this was an information-packed session today, and we're happy to answer any follow-up questions. In terms of day-to-day operations, I think one of the takeaways that you saw throughout this presentation was ask before you act. If you think that something is happening and you just want an extra set of eyes on things, talk to your general counsel, talk to someone in your legal department, and really just ask before you act in any sort of situation right now because of the heightened scrutiny that we have towards antitrust issues right now.
Great. Thank you so much. And thank you all for joining us on this webinar today. And we look forward to connecting with you all soon. So thanks very much and have a great rest of your day.
Thanks, everyone.